I'm ready whenever you are.
All right, everyone. So this is January 18th, 2023, a grand new year and the first trust webinar of this year. So we have with us the illustrious Randall and a lot of other illustrious clients and friends joining us from around the world. And those of you in other time zones, thank you so much for joining us at odd hours. Brilliance in Commerce is a consulting company with private placement platforms in the House of Freedom International Natural Law Trust, Project of Verite, which means the truth in French. And we have a number of programs you may have seen here on the screen and also on the website. We are signatories to the Worldwide Charter for Fair International Commerce, and we live up to it. We believe in it. And you can see there's a list of principles here. That is also on the website. So if you haven't already, take a look at that. It is a very important type of set of ethics that if the whole world were to follow, we would have a heaven on earth. Today is January 18th. We have our next one, March 15th, 2023, for the program open to anyone to attend and hear Randall. So please put that on your calendar. And we have a phone number for those who need a phone number, 360-200-7521. And we are going to get into some topics today. I'm Tansen Fairmont, the founder, consultant on bank instruments programs, former speaker on seminars, and author of a couple of books. Randall Hillner is the head of our trust department and the creator of the House of Freedom Trust, founder White Light Unlimited, trustee One People's Public Trust, and creator of the International Natural Law Trust. So Dominique Hackett assists and is a protege and is also helping to refine the trust and consult on it and provide sometimes trustee services, more often nominee grantor services. So she's there in the background. And we have other people on our team as well who some are present, some are not on today's meeting, but you'll get to meet them. Today's topic, the essence and uniqueness of the Natural Law Trust. And as I said to Rochelle, this is not a sales presentation, this is educational. So this will plunge in for existing clients to learn more. And those who have not yet got a trust, you will be pleased, hopefully, to learn a little bit about its workings, and certainly feel free when we open it up to questions and answers to raise your hand and ask or put it into the chat. All right. So Randall, please go ahead and put on your video.
There we go. How about that?
Complete with Hawaii.
Live in action from the island of Kauai. Here we go. All right, so we're going to start the year off. We're talking about educational, but I want to come back to the essence of what our program is all about and the ability for it to be what it is. It's in a sense, the trust is it can be either a simple trust or a complex trust. And the way we've set it up is that we have the discretionary power for the trustees to make it either simple or discretionary or complex. And it's up to the trustees to make that happen. So the more complex it is, the more understanding that's needed to make it all work. But because we've been doing this for quite some time, and a lot of you have been here with us for that period of time, you understand that it's simple and complex, and yet it's not easy to it's not hard to understand what you're going to do. You're going to run it like you would do any other thing in life, any other business, any way that you run your life, you would run the trust the same way. And it depends on whether you're a grantor or manager or a trustee, and we'll get into that in a little bit of time later on. But typically, there are at least 2 or 3 people involved, sometimes more. There's a grantor, and then there's a trustee, and then there's a beneficiary. Now, the grantor and the trustee can be one person, and the beneficiary can be that second person. Or you might have co-trustees, or you might have a couple that wants to create the trust together. So you'd have 2 grantors and a couple of co-trustees, and the beneficiaries can be multiple, can be singular or many as you want. It just depends. Sometimes when it gets going and you begin to have a number of people involved, and you can break it off, and some people will start a secondary trust. And or if assets get pretty full, your business is very successful, you might want to break certain parts of it away and put it in its own unique trust. Or you might have valuable cars or airplanes that you want to keep in trust, and you don't want to put them with other personal assets. So you would break that apart. One thing you never want to do is put a liability, which would be a car or an airplane, with your asset base, which is your gold, silver, stocks, asset portfolio. You wouldn't want to put it in if you have a house in trust, because if something happens on the road, then whatever's in the trust can be attached. So what we do is separate it out. And the whole idea of the trust to begin with is to separate your assets from your own pocket. Now, speaking of that, the beginning of this all came about a long time ago. We talked about common law trust, which comes from England, Britain. But before that, it came from way back in the time of Plato and Socrates, who had understood the ability or the uniqueness of contracting. So they would have a contract, and usually it was a way to separate the asset, and one person would be the person that previously owned the asset, and he would put it in trust, and he would have his friend or neighbor or somebody to be the trustee and watch it for him, which trickled down all the way into Roman law. And then Romans, of course, they swept across all of Europe and Africa and eventually went to Britain. And that's where common law really started to develop. The British people, after they finally got rid of the Romans, started their whole process of common law and how the courts were set up, the Court of Chancery, which was equality, the Court of Equity, and the Court of Chancery. And that's where a judge was brought in, or somebody was brought in, a third party was brought in, so that they could judge and make a decision on how it could be equally divided for whoever is claiming suit, one person of another. It's really a unique process that evolved over 3,000 or 4,000 years, or maybe longer. And so it's really exciting to go back and find articles. I mean, I still, in my research, will go and find somebody that's presented a different aspect of how trust law developed and how common law developed. But the idea is the basic principle of your right to contract. And that was brought to America in the Declaration of Independence, where the right of contract would never be annihilated, or it would never be usurped. So your ability to contract is held in high esteem now throughout the world. Wherever there's common law, there's the ability to contract. as we see here, based on the early British common law. But as I just talked about, it went way before that back into Roman times and into the times of Plato and Socrates, who would have discourses on equality. So the basic premise for common law is that you honor your contract and you do no harm. You can defend yourself and you have to defend the trust at times, but the idea is that you don't bring upon that harm intentionally. You honor your contract. If you honor your contract, pay your dues, then there's your equality, and that's where equitable interest comes in. So that's where the beneficiaries get to have the equitable interest. The trustees have the lawful or the legal ownership of the property, and the beneficiaries have the equitable interest or the equitable value of the property. Okay. Okay, so this is really great. This is the choice of roles. Now, Tanzan and I talked about this the other night, and then I have a client. We have a client that addressed this question. The same question came up for him. He said, and I'll read it to you. He said, well, I'll read it to you a little bit, but let me go through the process of the choices you get to make when you come aboard with a natural law trust. You have the choice to be the grantor and manager and beneficiary, which means that you're the one that creates the trust. You would manage the trust on a daily, day-to-day basis, and you would be the beneficiary. Now, in order to make that real, you have to have a trustee that's not related to you, or a co-trustee. One person can be related to you and one person could not. You need to have an independent co-trustee. So there you get the two options that you have when you come aboard with a natural law trust. You can be the grantor, manager, beneficiary, or you can be the grantor and the trustee. And his question is, if the grantor is the sole beneficiary and he dies, what becomes of the trust asset? And do you need at least one beneficiary? So I said, the assets belong to the trust. So here you've taken your assets from your pocket and you've put them into the trust for the benefit of somebody else. Well, if you're the manager, the grantor, manager, and beneficiary, then you would be putting the asset into trust legally owned by somebody else as trustee for your benefit. The other option is for you to be the grantor and the trustee, and the benefit would go to somebody else. I had one client who came in and he's the grantor and the trustee, and the beneficiaries were her grandchildren. So that's how the separation happens. So typically the grantor would have a letter of wishes or directions if the original grantor dies, and the same with beneficiaries and trustees. Over time, this will change. You got to remember that back in the days of Rockefeller, or days even going back to Europe, when they were going to go leave England and Europe and go across the Mediterranean for the Crusades, they left their property in the hands of a friend, or typically it was the church. They left it in the hands of the church because they expected to come back and their property would have been taken care of. Now, a lot of times they didn't come back, but because it was held by the church and there was a beneficiary stated, then that beneficiary, maybe the children that the knight left behind, would get to benefit and have the estate that was left by the knight going to war to protect the assets. So that's the role that you get to play. You get to be the guy that manages the daily basis, or you get to be the trustee and take care of a beneficiary. Okay, next. Okay, for those of you that have the trust, if you look at section 5 and 6, you'll see where it states how you're guided by the trust. And so you have not only if you're the grantor or the client, and you've chosen, let's say you've chosen to be the grantor and the manager and the beneficiary, then the section 5 and 6 would give the understanding to the trustees how they're supposed to run the trust for your benefit. And then they look to the trust, the contents of the trust, to see what the best way is to run the trust and to make sure that beneficiaries get what they deserve according to your wishes. So you have that. Trustees, and this is where the educational part of our monthly or other monthly seminar is to guide the trustees or to guide anybody, even a new client coming in, that how to set up and run the trust. And of course, you have the ability to go in on the BIC website, and there's a couple of books, one that Tanzan has written. We have a trust manual that I've written. It gives you a summary and a brief understanding of what to do when you become a board and become a client with us and have the natural law trust. So there's plenty of guidance. Once you become a client, then you have access to me pretty much on a regular basis. And Dominique is available if she's your nominee grantor and you want advice from her, then she's open to that. We have a new trustee in training, Laurel White. She's picked it up quite quickly. She's very intelligent. Both ladies are really intelligent, and they support me a lot as I'm getting on the other side of the stick. So these two ladies are going to come in and eventually at some point take over and be the one who's going to guide you down the road. But in the meantime, I'm still kicking away, and we have these books, and I have myself to look forward to and ask questions. Okay?
And clients can go surfing with you, yes?
Absolutely. And drink fermented coconut juice. These are not my girlfriends.
No.
Okay, so what we have is trustee authority. Actually, this is part of the trust document. This is where you have part of the trust. The whole is 3 sections on what the authority of the trustee is, what the powers are, and what the duties are. So in other words, it's laid out in the document. If you decide to come aboard and you're a trustee, you look to these particular powers to see what role it is for you to play and what the best way to do that is for the benefit of those beneficiaries. And then the beneficiaries, it's, as a trustee, you have to look to their interest and to the ability to distribute. And this is where simple or complex comes in. The simple part is, in a simple trust, you would be guided and be told that every so often you must take whatever's in the trust, whatever profit or income is in the trust, and give it out to the beneficiaries. The complexity or the discretionary part comes when the trustees have the discretion to either hold the new profit or the new income that's come into the trust. They can hold it within the trust, or they can give it to the beneficiaries. It's a choice that they have the discretion to make. So that's the uniqueness that we have with the natural law trust. And any well-written trust hopefully would have that within it. So there it is. It's in the trust document. If you already are a client and you have our document, please look at those sections. Again, a lot of the questions I get, I said, have you reread this particular section? Have you reread this particular section. And it's one thing to read it once, but after doing this for 25 or 30 years, and every time I come and do a seminar, I always look through the trust document to see what I might have forgotten or what I might have missed along the way, haven't talked about before. And that's the important thing to grasp. So don't take your document and just stash it away. The idea is to look at it, and whenever you make a decision with, concerning the trust, look to the trust document and look and see what your duty and the power is the way you might have to distribute those benefits out to the beneficiary.
Might be recommended to read the trust manual at least once a year, just to be reminded.
Well, at the minimum, the idea is that at least once a year, in the early days when we were doing commercial trusteeship ourselves, my partner and I, we would have a meeting once a year, preferably in the first couple of months of the new year. And a client would take us to a restaurant and we would have a business meeting there, and we would discuss what happened the previous year and what the client wanted to do in the future, the next year coming. And then, of course, the payment was that they would buy us dinner for the night. So it's once a year at least. And if it's a busy trust and there's a lot of business going on, it might be that it's twice a year, might be quarterly, and it might even be monthly. I make it a point with the work that I do, and especially through Tanzan, is that on a monthly basis, I'm upgrading the minutes of the trust. Okay, what happened this month? Where do we want to go next month? Et cetera, and how have the beneficiaries been taken care of for this last month? Okay. And part of the trust is the ability to have charitable deductions. The essence of charitable giving is always a concern. And so in this, one of the sections in the document is the ability to give to any charity it wants. And it also can receive gifts and donations from people for the benefit of beneficiaries. So can give and receive benefit for the beneficiaries. Third parties have to look only to the contract between the trustee and themselves and the signatures of those involved. In other words, the third party might need both trustees to sign, or it might just need one of the trustees. And also when you're opening up a bank account, depending on the bank may want to have both trustees, or it may be totally okay to have just one trustee on the signature card. Also, if you've set it up so that you're the grantor and manager, then the bank may want to have you on the signatory card, but you're probably also going to need at least one trustee on the signator card. And some banks won't allow the manager to be on the signature card, and you'd have to have the beneficiary be there to sign on the check documents. And if you have questions about that and you're a client, please feel free. And sometimes you may have to go to a different bank. Some banks are really open to what we have on the table, and some banks don't quite understand a trust. And yet, Tanzan said the experience, I think himself, he talked about where the same bank 2 blocks away, one said no and one said yes. So it depends on the relationship maybe you have with the bank. You've been perhaps banking with this particular bank for a long time. You have a relationship with the manager, and they're going to say, yes, we'd like to have your business. So it's really depends on the bank. And unfortunately, over in the last 10 years, banks have gotten more picky because of the way the government's been run. The banks have had to be more stringent in the ways they set up accounts. But there's banks out there that want to have your business. So there you go.
And
Anything
Randall,
else?
talking about charitable contributions, you could mention that the trust can be styled as a foundation, can operate as a foundation.
It could, if you set it up. You just have to write a minute and an amendment that says, okay, we're gonna do this, and the beneficiaries can be any number of other charities. So it's like you've created a foundation and out of the trust, and it's allowed to give to any humanitarian project you might want to take care of.
Yeah.
Okay, well, it's basically the gist of who we are. And then what happens after that is the rest of the trust is what we call the abstract. And in that is like the gist of the trust. So it outlines the essence of the trust. You have a memorandum and everybody signs that. The grantor and the trustees have to sign that. And then you have the banking contract. That's where you and the trustees go to the bank and you'd open up an account. You would have to, you want to take a copy of the first part of the trust document that's outlined in the instructions that are given to you when you become a client. And you have to take that part to the bank, leave them a copy, but don't leave the whole contract there. You want to, especially the minutes, they're private, and you want to keep those private. And then you have, I think there's it's just the minutes after that. And so what you want to do is you, like we talked about, you have minutes on at least a yearly basis. Okay, unless there's another note, I think we can go to the questions if anybody has any. Oh, the trust certification. There's a note. Okay, so another aspect is where the trustees sign, and this is where we talk about having it notarized. In the beginning days, it wasn't that important, but now that the banks have gotten more stringent, one of the documents in the trust is the trust certification, and what you do is you take that particular document to a notary and they notarize your signature, you and the trustees, and that is your certification that this document is a real document and that those who have signed on it are certified to sign it. Is there another note, Tanzan? Well, there's your addendum, and those are anything that you and the trustees decide that might need to be added. So in other words, there might be something that you want to do that's not available in the trust document. But if you and the trustees and the beneficiaries decide that that's an important new note to be had, a new way to run the trust, then you create an addendum, everybody signs it, and it becomes part of the trust document, like the minutes. And the thing about the trust is that the better paper trail you have, the better it holds weight. So it's not like nefarious businesses where you want to keep two books. And the idea of a well-done trust is you keep a very detailed process of what the trust has been doing and what it wants to do in the future. It's always kept on the benefit side of the beneficiaries. A clear paper trail. Oh, what if the trustees resign? Well, usually you don't have two trustees signing. One may leave because of death or illness, or he doesn't want to be a trustee anymore. And so the remaining trustee can assign one or two trustees. If you're the one remaining trustee and you want to resign, then you would have to appoint two trustees before you put in your own resignation that would take the trust over. Or if the beneficiaries would like to let it lapse and end it there, and the trustee, the last remaining trustee, has ability to take the assets and give it out on a pro rata basis to the beneficiaries. And then they get to choose whether they want to create a new trust and go from there, or end it all. Two participants raised a hand. Okay, do you have a question then?
All right, so we can go into questions, and everyone, if you wish to speak, click on the raise hand icon, or type it into chat, or if you've called in by telephone, you can press *9. All right, Jay, you've just got initial J as your identity, so you're on the air if you wish to be.
Hi,
Yes,
can you guys hear me okay?
yes.
Hey, Jay.
Hey, so is this trust, is it foreign, like outside of the United States?
Born wherever you want. If you're a client, you can use whatever address you want anywhere in the world to create this trust. And you have that address as the place where it was created.
Right, well, I mean, as far as like staying outside of the jurisdiction of the United States.
Well,
That
it
makes
depends
sense.
where you are. If you have the address and it's in Europe, and you are home based in Europe or wherever outside of the US, then it would, if you're not doing business in the US, it would be outside of their jurisdiction. But even if you create it in Europe or down in the Caribbean, and you come and do business in the US, then wherever you are contracting in the US, it would have jurisdiction, whatever that state would be, wherever you're doing business with the trust.
Okay, got it. So let me ask you this, as far as like opening a bank account, if you do it in the name of the trust with an EIN, doesn't that create some type of jurisdiction because the bank is not a natural person and it's actually an entity of the United States?
Well, that's because you're doing the banking in the US, and the EIN number is required by the banks here if you're going to open up a bank account in the US. If you go to Europe, we have clients, or in the Caribbean, where they walk in with the document and they put their own personal ID on the table, and that's all they need. And we've had that happen numerous times.
Got it. And I got a couple other questions about banking. I know you guys recommend funding the trust with like silver. So like, let's say you do that. How do you actually get the currency into the bank account? Like, I know you do it on a Schedule A, but how would you get the funds into the actual account?
Well, you would just assign it. Somebody would hold that property. In other words, the trustees would hold that property. So let's say you have gold and silver, you have precious gems, you have artwork. It would be held in a safe place under the name of the trust and the trustee signature. So
Okay.
it could be held anywhere by any trustee, and you give a safekeeping receipt for that particular gold or silver or whatever asset you're putting into the trust.
Mhm.
Could
And then
be a
how do you
valuable
how do you
car.
convert it into the bank account, like to actually get it into the bank account to use those funds?
Well, you'd have to convert it. You'd have to take your silver to a silver dealer or gold. If you had an expensive Delahaye car, you'd have to take it and, take it to the trustee or take it to the Delahaye dealer to convert it into cash, which
Okay.
would be quite a bit if you owned a Delahaye, actually.
Right, right. So the reason I'm asking is because I heard with Federal Reserve notes that could create like a third-party contract. So if you were to fund the account with Federal Reserve notes, can that be an issue where the trust could like get invalidated or cause any issues? So that's why I'm kind of asking the specifics about the silver, because I was concerned if we fund it with Federal Reserve notes, we can have a future issue, if that makes sense.
I've never had an issue. I've used Federal Reserve notes for a long time, and there's never any issue because I live in the US and I used US banking system, among others, also in Europe, but it's never been an issue.
Okay, cool. I have some other questions, but I'll let other people go. So thank you.
Well, that's
Thank
the
you,
way.
Jay.
I hope those questions help the other people here.
Yes, thank you so much.
Yeah.
We have another hand, but right now let's take a chat question, Randall. James is asking, at my current employer, I get RSUs. And he said that means restricted stock unit. It's in lieu of a salary. How can I change it from them paying me to them paying the trust? Will the employer allow this? Will the employer have an issue setting up my brokerage account for the RSUs?
It depends on the company. So in other words, you can ask them to say, I want it, instead of it coming to me, I want it in the name of the trust. And if they're okay with that, then the trustees would sign a contract between you and the company. The name would be made out to the name of the trust rather than yourself. It's all up to the company. You can ask and they can say yay or nay.
Yep.
Some companies want to keep you under the yoke of you being an employee, and they don't want you to be able to give it to a trust. And so it just depends on the company.
We have a hand up from call-in user 1, but it doesn't give your phone number. So I don't know how to identify you. And I don't know how to bring you on except perhaps ask you to unmute. So if you have your hand up, go ahead and unmute and say hi to us. Okay. While we're waiting.
Anybody else?
Yeah, all right. We got lots of questions in chat, so let's go ahead with that. The creator and one of the two trustees die in an accident. Who assigns the second trustee?
The remaining trustee or the beneficiaries or whoever's really intimately involved with the trust. You'd have to just reestablish the process. So that was the question that I read earlier, is that however it's set up, whoever's left, that's why it's best to have a co-trustee. So that I've never had it happen. I've never had one trustee basically die in that way yet. So it'd just be whoever's left would have to take care of the business. And typically if the trustee, the grantor dies, then there's usually a beneficiary around and they would have to step in and they would say they would need to appoint another trustee so it can continue on, or they would have to appoint a trustee and then they and the trustee would decide the best road whether they want to continue the trust under the new trusteeship or whether they want to dissolve the trust and start something anew.
Right. And your answer might be same or similar for the second part of Steve's question, which was the creator dies, who assigns a protector if needed?
Well, there wouldn't be anybody to assign a protector because the grantor is no longer there. And ultimately, it's usually the reason you have a protector is you're not the trustee. So when you set this up, if you're play the role of grantor, manager, and beneficiary, then you can have a protector ready to go. And so even if you don't assign a protector right away, you can have him on a wait list. Let's say you have a wait list, and if something happens to you, then the protector can be assigned to his duty in protecting the trust for the beneficiary's interest.
And James is
Never had-
asking,
Never had a need for that issue.
what if all the trustees resign? Can a new trustee be introduced without the grantor's permission?
Well, that's going to be rare. So I wouldn't know how to say that, but the grantor, if he wants to continue the trust going, or the beneficiaries, if they want to keep the trust going, would have to come together and assign, choose 2 new co-trustees.
Yes. Yeah, I've never heard of it happening. They might die in an airplane crash, but if the trust has assets in it, it's pretty likely they're not going to resign.
Correct.
Call-in user, it looks like you're unmuted. Are you there?
I am. Can you hear me now?
Yes.
Yes.
Hi. Sorry about that. My phone is acting up. This is Bernice. Hi, Randall
Bernice.
Tanzen.
Oh, hi,
Hi.
Bernice.
Hello.
You're breaking up a little bit.
Okay. Is this better?
No, but
Hold
it's all
on.
right. Just we'll
Hang
chat
on,
our
I'll
way.
pick up the
Keep going.
receiver.
You're in Northern
might be better.
California?
Yes, I am.
Well,
So, Randall, you mentioned an addendum that could be done by the grantor, trustee, and beneficiary all signing. I think that's what I heard you say.
Yes.
But I thought that once the grantor, signs and turns everything over to the trustee, the grantor sort of is out of the picture and doesn't have, power to make changes anymore. Am I wrong about that?
Well, in a sense, yes, you're right. But because the trustees are taking care of you as a beneficiary, then you have a letter of wishes. I think I mentioned it earlier, where you have the directions for the trustees and how they're there to take care of the benefit of the beneficiaries. And if the original grantor is not there, then whoever is the trustee is going to step up to the plate. As in your case, you're appointing another trustee to help you along the way.
Well, but I'm just thinking in general, if it's possible for the trustees to do an addendum, which would change some part of the trust, then there's no assurance that the grantor's wishes might be carried out. Is that
Well,
true?
but then they're in a breach of fiduciary responsibility. And I've never had that happen. In other words, if they're going away from or trying to take the assets away from the beneficiaries or the intent of the trust to begin with, then they would be in breach of contract and should be fired.
Yeah. Okay. But so then that would lead me to the next question. What law form is this trust under? You mentioned contract law, equity. Is it commercial law? Is there common law?
It's under the common law court or whatever, a court of equity. This is where you would go if there was an issue with that. The common law court.
But the trust is considered, it's a contract. It's contract trust, right?
Yes.
So it would fall under contract law in the state?
Yes.
Okay. Just trying to put together,
Right,
you know, what,
I don't know, to me, that's like, you'd still go into court of equity.
okay,
Whatever, you know, there's a court for criminal action and there's a court for contracts.
okay, okay.
Bernice, the
Uh,
permission of the trust to exist doesn't fall under any body of law except universal natural law. So that is never in question. That has never been brought into a court and will probably never be. The only thing that could ever be brought in are specific transactions, not the permission of the trust itself to exist.
okay.
Okay.
Okay, well, hopefully that would never be an issue.
It
But,
hasn't been so far.
And
Okay.
we can talk more about that tomorrow, Bernice.
Okay, all right, thank you
But
so much.
that's the basis, is that it's either under criminal law or under contract law. And if you're not in breach of contract, in other words, the trustees are doing their duty, then it's fine. And if they try to go away from the intent of the original trust document, then they would be in breach of contract.
Okay. Okay, so then it would be under contract law. I got you. Okay, thank you.
Thank you, Bernice.
You're welcome.
Mm-hmm.
Will Barney, you're here and you want to say hi to us. So go ahead and unmute and say hi.
Hello.
Hi.
Glad to join you.
All right,
And
now you're
everyone-
show with Tanzan.
Will Barney, we to make an announcement, everyone is going to be sharing with us his global news January 26th. So put it on your calendar. Former banker Will Barney and speaker about world news extraordinaire will be joining us January 26th.
That'll be fun. We'll do that next week. Just a couple of comments regarding trusts. I've interacted with these documents a number of times over many years. I had actually a close friend who was a part of the trust. Father put this together to take care of the family when he sold the business. And a very interesting thing occurred, and that is that he wanted to cover every contingency. And the document ballooned to 500 pages to make sure that, you know, this son wouldn't do this, or there were certain criteria. It became an utter nightmare for everyone involved, beneficiaries, trustee. And one of the things that fortunately, I didn't have that experience, but in watching this from afar, I came to realize that simplicity is a beautiful thing. And that if you give a trustee the power to see to the needs of the beneficiaries in the moment as they see the need to do, in other words, give them some discretion, I think the intent can always be met in a manner that applies to the current conditions. And it can keep things very simple and functional, and certainly help everyone along the way. Just a comment. Thank you.
I agree very much. And that's one of the sections in the trust document that we have, is it's a discretionary process where the trustees have the right to say yay or nay in the moment. And so it doesn't have to balloon to 500 pages. It can just stay fairly simple, and it's up to the trustees to keep it simple, yet they have the ability to perform in the moment and take care of the needs of the immediate beneficiaries.
Yeah, because there's always these questions. Oh, what happens if a beneficiary's in a car accident and now they need long-term care? Well, you need the trustee to be able to work with that, right? And to make
Right.
those adjustments. And as long as you
Exactly.
trust the trustee is and their judgment, I think everything works really well. Just a comment about jurisdiction, as I've had to deal with several parts of the world. my understanding is contract law, it is somewhat outside of a jurisdiction unless you're doing business within a jurisdiction. In other words, this trust should be usable in any country as long as the country has law that protects contract. Isn't that correct?
That's correct. That's my understanding. And that's been my experience with clients, across the country, across the world. So in other words, it depends on where you're contracting. If you're in the US, then you're under that jurisdiction. But if you're not in the US, you're under any jurisdiction and where you're playing the contract. Is that
Yes.
your understanding as well?
Yeah, that is my understanding as well. In other words, you don't need a country's permission to exist.
Right.
You just need their law to uphold contracts.
Correct.
And then you can function in any way you desire. Okay, thank you.
Correct.
That actually provides some clarity for me. Thanks, Randall.
That's a great comment. Thank you.
All right, from chat, Alan has asked, how should trustees respond if any alphabet agencies challenge the trust? And Randall, let me just say, Alan, that has never happened to our knowledge to any of our clients, and we think it's extremely unlikely it ever will happen. And first of all, it would depend on challenging for what. Again, it could not challenge the permission or the right of the contract trust to exist, but rather maybe potentially specific transactions. Randall?
Yes, and in that case, the trustees say, well, we'll take it under consideration. Please make sure that it's in writing and that your part of what you're asking is under penalties of perjury and that you have the right to ask this under that penalty of perjury.
Beautiful, beautiful, beautiful. Yes, absolutely. Jay, you had more?
Yes, do you have the right? I think Will has probably found this true as well, is do you have the right to be on my doorstep? And that's with anybody. That's with any, even if you just have a simple home, anybody that is not the owner does not belong on your property unless they have permission.
Yep. There you go. Jay, you had more you wanted to say? You have your hand
Yeah,
up?
hey, in reference to what Bernice was saying, I think I get where she was coming from. Like, for example, in the trust indenture, does it state that it's like actually universal natural law, or are you referencing it's like contract law?
We just reference it under the common law. And depends, okay, so the section is there under the common law of this state. In other words, most of our clients are in the US. And so it would be, if they're in Arizona, it would be under the common law based out of the address of Arizona. If it's in whatever state that it's in, it's under that common law of that state.
Okay, yeah,
And
because we
and
want
it
to
keeps
avoid statutory law, of course.
Well, that's why we don't say state of California. We say under the common law of California state, small s, which means it's under the common law court of contract, and it's not under the state of California statutory law.
Okay, great. And then that went back to like what I was saying originally, because I've been doing a lot of research, like the way things are worded. Like if it says United States, it's like you get into all the statutory stuff, but if it's like listed a different way, I mean, I want to get into the whole thing here, but that's why I was asking those questions.
Right.
Thank you. So this is a great call, by the way, really appreciate it.
There's a great deal of difference between capital U, capital S, United States, and small u, capital S, United States. One is the corporate structure, the US, and the small u states is the common law of people.
Yeah, and we want to stay out of that, the capital.
Much as we can.
Yeah. A couple of questions about nominee grantors, because I know that's an option you guys have, and I've heard you talk about it a lot. So if you're using a nominee grantor, that's obviously going to step out and the trustees are going to take over. When you're first creating the trust, you have to fund it. So let's say you do like $21 silver. I've heard you guys talk about a lot. Or let's say you put Federal Reserve notes in. If that's coming from the nominee grantor, isn't that seen like, and they're not getting any? So let's say the nominee grantor is putting that in, or maybe
Well,
they
the
don't.
nominee grantor may not put any asset in at all other than the signature, and that the asset going in is put in by the beneficiary or the trustee for the benefit of the beneficiary.
Right, that was my question, because otherwise it would be seen as a gift instead of an exchange if a nominee grantor is doing it, right?
Right.
Okay, yeah, so we want to avoid that, thanks. So the trustee can actually put in something, assign something into the trust and not receive back any beneficial interest?
If he does, if that's what he wants, that's what he does. In other words, there's a nominee grantor and the asset that's put in is put in by the trustee for the benefit of the beneficiary. Now, typically in the case where the trustee is really the one that's putting the asset in, is that he would also be the grantor. If he's going to be the trustee, he might as well be the grantor. So he would be the grantor and the trustee. You put the asset in for the benefit of the beneficiary.
I see. And what if you have like a management trust as, or just a trust in general as the trustee or the beneficiary? Like, do those people need to be named in the trust indenture, or can you just name the actual entity, the trust, without having to name the individual people?
Or just the beneficiary, the way I would write it, beneficiary either on Schedule C or at the end would be ABC Trust or ABC Company or ABC Humanitarian Project.
Mm-hmm. Yeah, because for someone that maybe doesn't want to, actually put a name in there in either one of those instances, so that is acceptable to do that then.
Yes.
Okay, that's wonderful. That's really wonderful.
And
All
Jay,
right.
just to make you aware that if a trustee puts substantial assets in and needs or wishes to have some compensation for managing the trust, there is a housing resolution and there's a spiritual resolution in the minutes that can be put in for the trustee to have certain expenses covered, certain withdrawals from the trust in his best fiduciary discretionary management for the benefit of beneficiaries. So the trustees can be compensated in that way.
Wonderful, wonderful. And I know you gentlemen mentioned the foundation a couple of times. So can you have like a specific foundation purpose, and can that then be like the sole beneficiary of that trust?
Well, the idea is that the trust would be set up so that the beneficiary of the trust would be that project.
Mm-hmm.
So in other words, you don't have to have the trust become a foundation. It already is, in a sense that it can give to whatever the beneficiary can be, whoever you want it to be. So
I got it.
like
So there doesn't have to be special wording in there. You could just maybe state something about a foundation, but then actually have the foundation as the beneficiary instead of a person. Okay,
yes.
That's pretty cool.
I have a number of clients, and they have themselves down as 10 or 20%, and the 80% left is going to a humanitarian project that they have in mind.
Mm-hmm. And now, can you do that without, because some people that want to avoid incorporating and doing LLCs and all that stuff, and I know you could do business in the trust, so you can avoid having to incorporate. I know obviously if you have a nonprofit, that's like a 501c3, but are you able to set up a foundation without having to incorporate? Is there a way to be able to do that or no?
Well, that's a whole different game, and that's a very different discussion. You're talking about a 501c3 nonprofit or a 508, ministry. So the trust is left as a trust, and the beneficiary can be any one of those things. So in other words, you wouldn't, the trust is set up and the beneficiary is whoever you want it to be. And it doesn't have to have a name, a specific name. It can just have a name of a foundation or a ministry or whatever you want it to be.
Right. And then you can make it discretionary where you can decide when you will set a distribution. You don't have to, if funds come into the account, you don't necessarily have to give out the beneficial interest right away, from what I understand.
Correct. That's why we call it a discretionary trust. Trustees have the ability to say yay or nay, for, as Will was saying, that, in the moment, you
Okay.
need the trustees to have the discretion to do what's necessary for a beneficiary at the time.
Mhm.
And like, you have two beneficiaries, and one is a scholar and needs college funds, and one is in an accident and needs more attention on rehab. And so the trustees can decide, how to play out the asset base so that each one can be taken care of, even though they might be different.
Right. So I know you guys call it a private irrevocable trust. So do you also call it a private irrevocable discretionary trust, or you just have discretionary listed inside the trust somewhere?
It's one of the powers of the trustees. It's one of the intent. It's in a section within the trust document that this is a complex discretionary trust.
Cool. Okay. Again, thank you so much for these answers. I hope these are helping the other listeners as well. Thank you.
Thanks for the
Thank you,
question.
Jay. Excellent questions. Okay, Alan, you had a couple of questions in the chat about banking. You said, so we can't have a bank here. I think you mean bank account. Yes, you can have bank accounts in the name of the trust. Most of us do. You said, what do we need to say to banks to open an account? Those instructions come with the trust, in the trust. So I guess by asking that, you must not have one of these trusts yet. Randall, you want to add to that?
No, you just, I'm sorry, I missed out. Say that point
What do we
again,
need
Tom.
to say to banks to open an account?
Oh, you want to, when you walk into the bank, you're not looking for anything special. You just say to the bank, I want to open a checking savings account for this trust. And as long as you have the paperwork and the trustee with you, then you should sit down at the table and you begin to work, negotiate what kind of account there is at the bank.
Yeah, and in the trust, there are instructions on what words to say, what words not to say.
Right.
Don't use words like natural law or common law or sovereign or pure or anything like
Say
that.
it's a private irrevocable trust.
Exactly. Yeah, so the instructions come with it, Alan. Frank, you have your hand up?
Yes, you guys are amazing. Thank you so much for taking my question here.
Thank
I'm
you.
a little confused because I have a friend who has a trust and his is revocable. And we were reading it, and when we were reading the trust, I realized it says that if any of his heirs die, the King of England will receive his earnings. I was
Okay.
baffled because he paid $5,000 for that trust. And I'm saying to him, but did you not know this was on there? He had no clue.
You can get a
So-
revocable trust online for $200.
Crazy. And so I said to him, look, I have a cousin who's into this, that he's the one that geared me this way where you guys are at. And when I'm listening, you guys are doing the difference between the revocable, irrevocable. Yeah, that's kind of crazy how that whole thing pans out. But I have another question for you that my cousin who introduced me to this stuff, he told me that he went with his to ask the question at, I think it was Chase Bank. and Chase would not open a trust for him that was irrevocable. Is that true? Or how true is that? Why wouldn't that be? Just
Uh,
find out.
Chase Bank,
I'm all new.
wouldn't that, you'd have to say which Chase Bank, which town, which branch, and why wouldn't they open up an account for an irrevocable trust? Again, it depends on the banker. I think the bank manager and the particular branch you're at. I mean, I haven't had a Chase account because I haven't worked with Chase, but when I was in California, I worked with a number of major banks.
I remember, Randall, years ago, Chase said no to me, and I told you they actually gave their reason. It was that the grantor was not signatory in all the trust documents, and you started laughing. He said, "Of course they'd like it to be a grantor trust because it weakens it, makes it more vulnerable."
All right, the only thing a grantor or trust does is eliminate probate, but it doesn't give you any privacy.
And no asset protection.
That's correct. If you have a revocable trust, whatever you have in as assets in the revocable trust, in a sense, your friend was right. They do belong to the king. Because the king owns all of the banks in the US,
Yeah.
the Federal Reserve and all of that. That's a long story. That goes way back. That's a 6-hour discussion.
All right. James is
Sure, you've
asking.
heard of that, Will.
James is asking, if I use the trust to apply for a job, will it be able to get past the background check without my SSN?
Depends on the job. You either have to have, when you go to a job, you're gonna have to have an SSN or an EIN number.
He could be an independent contractor.
Yeah, but they'll want somebody or some number in order to send a 1099 to, more than likely.
Yeah. So what you could do, James, is propose that they contract with you as an independent contractor. You're not an employee. And they sign that their payments to the trust will satisfy their payments to you. And the 1099s would go to the EIN of the trust, and that's not a problem.
Right.
Will, you have some more comments?
Can you hear me?
Yes.
Yeah.
I've had no issues with being able to open trust accounts previously. The question is, do you know your banker? In fact, I've had people come in and with trust documents that just wanted them notarized. Well, we do the notary, and then what's the next thing? Oh, do you want to open an account? Right.
Yeah.
And so
would think.
if you go to a bank and a banker that they're used to seeing you and you've already done business with them, most of them won't question that at all because there's a relationship. So
Right.
I think you just don't want to use buzzwords, if I can put it that way, that'll set off alarms. Just,
Yes.
hey, we want to contract, we have a trust we're trying to take care of some beneficiaries, can help us with the notary. Most of them will be like, oh yeah, sure, we can notarize it for you. And if the next thing is, well, can we set up an account? Well, usually there's no question. It doesn't matter. And it's the same thing with Chase. I was a banker at Wells Fargo. I can tell you that Wells Fargo didn't have a problem, but it really depends on the banker. They all have a right to say yes or no. And so, if it were me, I would be, you'd want to work with a business banker, not just your average teller. And most of them, if you've got a relationship, would be more than happy to open a bank account.
Correct. Thanks, Will.
Absolutely. Thank you, Will. Okay. Jason is asking, where does the beneficiary derive the authority to appoint trustees? I think
It's
you
in the
may be
document.
referring, Randall, to when you mentioned if both trustees had resigned or died or something.
Well, beneficiaries have to decide, I mean, if both trustees happen to pass, then the beneficiaries have to decide what to do. So they have to either appoint a new trustee, or there's documents that are prepared already that have like, I write a lot of trust where there's a trustee and then a successor trustee. So if something happens to them, then the first trustee is replaced by the successor, and there may be a list. The grantor may have 2 or 3 people in line. I have clients that have their sons and daughters as successor trustees when they come of age, so that they can take over and be part of the trustee for the benefit of that irrevocable trust for the family.
And that's the reason to assign the successor trustees very early in the existence of the trust.
Right.
He's,
The bank, if the bank is going to see a document, he wants to see that there's a successor trustee, because the banker is on the hook to be the trustee of the account if something happens to the trustees. And so they want to see that there is somebody they can call and say, trustee has passed on or is incapacitated. We need you to step in, come in and sign the paperwork.
right. And Jason also asks, who holds the trustees accountable for breach of trust and how is it enforced?
Beneficiaries. Beneficiaries could hold the trustees accountable. They're under contract for the beneficiaries.
And how is it enforced?
Well, the beneficiary would bring suit against the trustees.
Mhm.
Again, it would be under contract law, and the trustees breach of contract, they can be sued. And they know that right in the beginning because it's in the trust documents. And before they sign as trustee, it would be very important for them to know what they're signing, especially if they're going before a notary.
All right, James asks, if we use the trust to hire W-2 employees, will we have to file tax return or can we just set up payroll and pay payroll tax for them? How would you set this up?
Exactly as you said, just set it up as a pass-through entity where it's it's just passed through the trust and given right to the person that's the employee.
And ideally, make them have their trusts as well.
Well, it's hard to have employee and have a trust be the employee. Usually the employee is a person. If you do an independent contractor, then that's a different process.
Yeah. All right, David is asking, would like to ask if the infinite banking concept would work with a natural law trust.
The infinite bank process?
Right, I think it has to do with insurance.
I'm not familiar with it. I wouldn't really know.
Well, David, yes, you would just make the trust the holder of the asset of whatever benefit is generated by the infinite banking. So yes, it's just like any other entity, an individual or a corporation. The trust is a superior holding vehicle that can hold any asset generated by whatever means.
That's true.
Shebriel is saying, good evening. This is my first time here. Welcome, Shebriel. How does one learn how to be a trustee?
Well, there's a book that Townsend's written, and there's the trust manual that I put together. And if you want to really delve into it, I have a substantial bibliography that will give you as much information as you can hold in your brain. but Dominique does, I think she has a class on trusteeship, and I'm always open to any questions you might have for being a trustee. And I haven't thought about doing a class yet, but I can certainly guide you of where to find the information.
Mhm. And Jason, you have your hand up. You would like to say hi to us?
Yeah, hi. Thank you so much for doing what you guys are doing. It's beautiful. I enjoy your energies and I enjoy your question and answer. And thank you for answering those two questions that I just put in the chat there about the enforcing agents, the beneficiary being the enforcers. My question is this: if this is a natural trust and we're getting an EIN and we're going into a contract law, aren't we kind of walking on a slippery slope of going from a private trust to the public, and now we're double-minded in that way, and it could work against us, especially if we're using a public bank?
You don't have a choice. If you're going to be in the banking system and you're going to do business in the economy, especially let's just say in the US, you're going to need a way to work with the banker. Like Will talked about, you have a relationship with the banker. Yes, it is, but there's no other way around it at this point in time, where if you're going to do business, you need to have an account or a banking process in hand.
Thank you for that. My follow-up to that is, if we are going to be playing in that world, regardless if we have a natural trust like what we're creating here, and we're getting an EIN, doesn't that also open the doors for three-letter agencies and other entities to attack the trust and confiscate the res because we've contracted with them out of no other choice?
It's a whole other ballgame. There's, first of all, we already talked about it, that if ABC, somebody comes to your door from the ABC soup company, then you'd say, where's your authority to be here, please? Sign it under penalties of perjury, and then you take it from there.
Meaning have those who are knocking present whatever documents they have under the penalties of perjury.
Correct.
And if they have a court order just from a corrupt court or whatever, and they say, yeah, we have this particular document here, that's the authority that we have to confiscate your property, and they break the trust, and the trustee has no recourse.
Well, you may have to find a lawyer, take them to court.
Mm-hmm.
I mean, they're not just gonna come in, they're gonna put a lien on your property, and the first thing you're gonna do is argue in court that how did you get the lien? Please tell us under penalties of perjury. Otherwise, it's theft. And yes, sometimes they just come in and they take your property, but sometimes they just shoot you.
Yeah. Yeah. And I'll just, the final follow-up question to this, just so I'm clear on that. If this is a common law trust, natural law trust, but EIN numbers and, three-letter agencies are not in common law courts. So how do we hold them accountable in a common law court if they're not in the same jurisdiction?
You just hold them accountable. Say, prove that you have the authority to do this under penalties of perjury.
And is the notary and penalties of perjury, is that not public as well, as opposed to private?
Well, yes, it's public, but they have to step up to the plate. But you're getting into a discussion that's way down the road, and it's not really the time and place to go there.
Okay,
This
no
is
worries.
about how to run the trust in a proper way.
Beautiful. No worries. Thank you so much for being out here and sharing this information. I love the colors and imagery on your websites too, and on the Zoom. Thank you so much.
Sure.
Thank you. And Jason, Randall, if I can just comment, you're worrying about things. It's almost like worrying, what if the sky falls?
Right.
we have said repeatedly, in our experience of, at least my experience of 3 decades and Randall's of 4 or 5 decades, and his mentors maybe 6 decades back in time, and thousands of clients all over the world, not once has any of us ever experienced the kind of attacks that you're talking about. And if you are anticipating that kind of attack because of whatever activities you are engaged in, you may not want to be using this kind of trust. We attract peaceful people who stay out of trouble, and our people stay out of trouble. So stop worrying about what if. These things just, it's like a speculative, oh, looking down, you know, what if I fall, you know? And if you're walking a tightrope, keep your eyes on the destination. Where are you going? Don't look down. There's a saying from the Native Americans, he who keeps his face towards the sun finds that the shadows fall behind him. So to everyone who is worried, oh, we're in a natural law trust, we won't be protected, now we're vulnerable. I want to remind you, do you realize that statutory corporations get attacked every day? LLCs get attacked every day. 501(c)(3)s get attacked. Statutory organizations get lawsuits and confiscations a whole lot more than any natural law trust. Like I said, we don't know of anyone who has ever had a natural law trust be penetrated or invalidated. It's 100% success rate. So what are you worried about? Randall, if you want to add to it, that's fine. But I just had to say, there's a lot of people worry about these things for nothing.
Yes, like I said, it's a different conversation, and it's not what we're here to do today. We're here to say, this is how to make your trust work and make it successful, and not to worry about the fallout from what if, like you said.
And it's sovereign in the sense that it didn't derive authority from any government to exist. But you don't go around touting the word sovereign to banks or to agencies. And we don't emblazon it in the title of it, you know? So, and doesn't a sovereign have the right to interact with the system? You're all worried about EINs and contract and, you know, notaries and public and dealing with the banks. Well, sure, that's the world. As Randall said, that's just life. That's just life, business as usual. But just because you interface with that system and use the trust as your vehicle doesn't make it subject, and it doesn't make it less than sovereign, just because it interacts with these systems. Okay?
Very good, Tonson. Thank you.
So, Steve, if a trust creates a trust, who assigns the trustees?
The people, trustees from the first trust would assign trustees for the second trust. Let's say you have one trust and they want to create a second one. One of the trustees from the first trust can be a trustee, but you'd need a second independent trustee that would not be involved with the first trust. It's just like your relationship when you set it up. You can have one related trustee, but the second one has to be non-related. Same idea.
Beautiful. Okay. Dominique, you've got a question in chat, but would you like to say hi to us verbally? I'll ask you to unmute.
Hello.
Hi. You're saying, is it okay for the grantor to exchange the initial 25 U.S. Treasury notes and comments in a letter to trustee that this exchange is for units of beneficial interest given to a beneficiary? This is an exchange, not a gift, just confirming.
I'd agree. I agree. If it's basically when the client comes and pays for a trust, that's part of his creation and setting up the asset base. He's right there. He's paid money in, he's going to put assets in, and it goes from there.
Okay, Dominique, there you go. Simple answer. Ross is asking, can a beneficiary of a trust be another trust?
Yes.
Simple answer, yes. Michelle is asking, what does having a grantor eliminate? Not sure I understand your question.
Somebody's got to create the trust. There has to be some kind of grantor settler involved.
Alan is saying, so in that case, a 1099 issued to the trust, if the 1099 goes to the EIN of the trust, isn't that liable to tax? And Alan, you have to understand what statutory and non-statutory means. If you can start wrapping your head around the non-statutory philosophy, you will begin to understand what the word exception means. Okay? So I always tell Randall, I tell people that exception is way more powerful than exempt, because exempt is a statutory term that the tax agency can give and it can take away, but exception, it didn't give and it cannot take away. So if a contract is written under a universal contract law and is not subject to the statutes of a particular parliament or Congress, then Alan, you tell me, where does that make it liable for any kind of statutory requirements? I'll put the
Correct.
question back to you. And Jay is saying, if a management trust is named as the trustee, does a successor trustee need to be named?
Well, the banker might require it. Depends on the bank. In other words, if there's a management trust as trustee, then there might be two managers. The management trust might have to have two signatories work with the bank. So in other words, as long as a management trust is a business and has multiple people involved, then that would probably qualify as long as they work with the banker and the banker says, yes, you can do that. We'll take that as the ability that you will take this on forever.
Shirley says in the UK, you can register as a non-taxable trust. And no, we would not recommend that. It's not necessary. If you do that, then you suddenly subject your otherwise sovereign contract to their jurisdiction and they can remove that exemption anytime they want to. Would you agree, Randall?
Yes.
So yeah, don't do that.
No need to register
No
anything.
need for it. Exception is way superior to exemption. Yeah.
I
And
saw a
there's some-
question about a restaurant.
A restaurant. Go ahead.
Owning a business. A trust can do anything any natural person can do. Whatever business you're in, as long as it's legal, is an acceptable process for the trust. An acceptable asset.
So the question Randall just answered is, if I decide to own a restaurant, which would require multiple licenses from the state to be able to operate, wouldn't it be worth it to put it in a trust since it would lose its privacy?
Well, you'd have a trust to hold the restaurant and all the licenses, and then you have a second trust to receive the benefit of it.
There you go.
And that's the issue with whether it's you're setting it up as an individual or you're setting it up as a business. It's the fact that the trust has the ability to have a beneficiary that would receive whatever funds come through. It's always a pass-through.
Absolutely. Thank you, Randall. And there are some comments in the chat relating to our previous discussion. Ross is saying the government or any other statutory entity cannot tax another entity that it did not create. Yes, Ross, thank you. That makes sense. And Dominique says exempt means you must file Form 1041 as the IRS has gifted you the privilege of being exempt. An exception is more powerful based on the BIC experience and research. So Dominique, yes, absolutely. Thank you for that. Shirley saying, I need to have a URN number, which is like an EIN. Yes, but again, any number, any government number in any country is for banking purposes only, not for taxability. And Jay is saying, how is it that a beneficiary can eventually become a co-trustee?
Well, it would be down through time. It may be that there's a direction from the current grantor or beneficiaries that, or the trustees, that say at some point those beneficiaries have grown up and they've educated themselves, and we want to appoint one of them as a trustee, but then they would have to give up being a beneficiary.
Be up to the discretion of the
That's the
trustees.
bottom line is you have to choose to be either a trustee or a beneficiary.
Yes. Jay is saying, I'm wondering why the beneficial interests, why there are beneficial interest units and also trust certificates. Isn't one or the other sufficient to state the beneficial interest?
It's just a more formality when the beneficiaries are listed on a Schedule C, and we give out certificates that are given to the beneficiaries that tells them what their ratio or how many units of beneficial interest they're entitled to. And those would change through time, either with added beneficiaries or minus beneficiaries. And just a record keeping, it's like a gift certificate. You have so much interest, you can go to the store and you get so many t-shirts for this certificate. I've been there, I got the t-shirt.
Michelle is asking, I think she's trying to clarify her earlier question. What does having a grantor eliminate? I ask for when going to the bank to open an account, the grantor should not be a signatory on the account.
A bank, usually on a grantor trust, they want the grantor to be the signatory, or revocable trust, because the grantor is the one that still owns the asset in his pocket. That's the revocable trust basically just eliminates probate. It does not take the assets out of your pocket and put it in a separate trust. There's no separation in a revocable trust.
And Michelle says, can I talk? Yes, please raise your hand or dial *9 if you're calling in, and we'll make you heard. But Randall, while we're waiting for her, you want to tell people why a grantor trust is a sham?
A scam?
A sham.
Oh, it's not a sham. For people that don't know, and especially older people that have a revocable trust, maybe it's all they've heard of, and it does eliminate probate. But for people who want to take the next step, you want to have a private irrevocable trust, because then you're the exception to the rule. Over the revocable trust does avoid probate. But that's how a lot of lawyers earn a lot of money. They're probate lawyers. And so they don't want you to know about irrevocable trust. They want you to have a revocable trust, because then they can take some of the money for their process of probate.
Is that synonymous? A grantor trust and a revocable trust? Is that synonymous?
Not necessarily, no.
Okay,
A revocable trust is the grantor and the trustee and the beneficiary. A grantor trust is just a name for a trust. It's going to be irrevocable or a revocable. I think it's just a title you put on particular contract.
well, I think it would help for everyone to understand your explanation of why our trusts are not grantor trusts.
Because they're irrevocable. And the grantor is not is separated from his assets. That's the best explanation I can give. A grantor trust is the grantor maintains ownership of the asset, whereas in an irrevocable trust, the grantor is giving up ownership of the asset.
Exactly. Thank you. And Michelle is here now. Go ahead, Michelle, you have your hand up. You want to clarify your question?
Thank you so much. Sorry for the confusion. I think you answered my question in terms of the fact that the benefit of the irrevocable is that it eliminates probate. But when we were talking about the fact that the banks try to impose or require that the grantor be a signatory on the account, my understanding as a grantor, like you just pointed out, is once he does the grantor, once he signs on the trust, he's out. And so there should be he should not be a signatory on the bank account.
No, he
Right.
can only be a signatory if he's either as a manager or a trustee. Now, again, it depends on, as Will talked about, the relationship with the banker and the particular bank that you're doing business with. But typically, the revocable trust is there's no giving up of the asset. In the private irrevocable trust that we create, there's separation between the grantor or the person and the assets.
Okay,
Whether
so
they're a trustee and they're given assets to the trust for the benefit of somebody else, or they're the grantor and they're the beneficiaries. But in that case, it would be the trustee signing the bank account and not them. So you just have to have the distinction that either I'm going to be a grantor with a revocable trust and no separation of assets from my pocket, or I'm going to be a grantor or a trustee and there's going to be separation from my asset base to the beneficiaries.
okay, thank you. So question, what's the benefit of being a grantor and a trustee versus just having an independent grantor and a separate trustee? Because I'm doing this for my trust for my son. So is there a benefit to me being the grantor and the trustee, or should I just have a random grantor?
I would suggest to you that you be the grantor and the trustee and that your son be the beneficiary.
Okay, all right. So then earlier on, thank you for that. Earlier on, you said if I wanted to do an addendum, you said me or you said you and the trustee can create an addendum. So in that case, it would just be me, right?
You're right, but you're under fiduciary responsibility to your son. So you're only going to do an addendum if it necessitates, in other words, there's some need for it to happen that's not already granted in the trust document itself.
Got it. Okay, super. Thank you so much for your answers.
Thank you, Michelle.
Okay, thank you.
All right, Randall, we have from Jay. Can a nominee grantor after resigning become the successor trustee, or does that invalidate the trust?
You know, he could, as long as he's not a beneficiary, he could be a successor trustee. As I said, you can't be a trustee and a beneficiary. So if you can be a successor trustee and a beneficiary now, but in time, if you become a trustee, then you can't be the beneficiary. You have to turn your beneficial interest to somebody else.
But the grantor, after resigning, could become a successor trustee.
Yes.
Okay, good.
Well, yes, the grantor can be the trustee right from the get-go, or be a successor trustee later on.
Right. Audrey says, can I put an interest-only mortgage leased property into my irrevocable trust?
You can, depending on whether the bank or whoever holds the mortgage allows that. So in other words, if it's okay with the lender, then you can do that. But you have to check with them first, and don't do it without checking with them first. Because then we call in the loan.
All right. James says, can the trust carry debt, bank debt specifically?
Yes, as long as the bank allows it.
Yeah, the trust would have to have some credit, maybe build up some credit.
Sure. If you put your house into the trust and it has a debt or a mortgage on it, then the mortgage follows the property. And so now the trust is liable to pay the mortgage.
Mhm. And I think Jay is asking something you already answered. If you are not the grantor, can you be both the trustee and the beneficiary?
No.
No. Okay. All right. Everyone, if that's it, are there any other questions? We can wrap up here.
Thank you very much
Any
for
other
joining us today.
Statement about the essence and uniqueness that you want to conclude with, Randall?
No, just that what you've got in your hands, if you've got it already, treat it well. And if you haven't got it, then get it and treat it well. And it will treat you well in return.
Randall, I have to say on behalf of everyone how much we have appreciated you. I know that all the clients I've ever spoken to who've had some experience with you, and I get these comments regularly and recently that they appreciate how you support them. And you enjoy your work, you enjoy your clients, and they see that you know your stuff, you've done your research, you're very knowledgeable, and you're very friendly, and people appreciate that you've been giving us great support.
Thank you very much. You're most welcome. It's my passion.
So everyone, March 15th for the next time with Randall on. And this coming January 26th, join us for the Will Barney World News update, and we'll put it into an upcoming newsletter. So
Yes,
aloha.
we're done rambling on. We'll ramble on now, but we won't ramble anymore.
Okay. All right. Thank you. Thank you. Thank you. We started the year out great, Randall.
It's my pleasure. Thank all of you.
Okay. Aloha.